right now. Steve Halbrook, Second Amendment attorney and scholar, join us. How are you, Steve?
Great. How are you today, Cam?
I am fantastic. I appreciate you joining us. So yesterday we got the news that the new attorney general there locally in District of Columbia is dropping the defense of the outright ban on the carrying of firearms in Washington, D.C., and instead they're going to try to defend the laws that are currently on the books, which allow for the issuance of a concealed carry license in very, very limited circumstances. Steve, does this indicate that gun control advocates don't want to try to defend an utter ban on the carrying of firearms? They don't think that they would win this case if it got to the Supreme Court?
Well, they don't want to try to defend a case where absolutely there is no bearing of arms whatever. They will defend their current law, which was passed in the wake of the prior law being validated, where you've got selective discretionary issuance of carry permits. There are several courts that have upheld that, but remember that the last absolute ban by any state in American history was that of Illinois, and the Seventh Circuit really got them good in terms of invalidating that law. There was really no question about it. So, D.C. was warned before. When they had their handgun ban, they were warned, don't let this case go to the Supreme Court. We might lose. That's what the anti-gun people said, the ones who didn't want any Second Amendment right to be recognized. And D.C. took it to the Supreme Court anyway and got badly beaten. So what they're doing now is the craftier approach. Let's get permits out to 2 or 3 people or maybe a dozen and deny them to everybody else and go with that law, take our chances with that.
Yeah, so to that end, I said earlier in the show that I'm not an attorney, but one of the problems I see here is that the District of Columbia still insists that you don't have a right to carry a firearm or to get a concealed carry license for the purposes of self-defense, right? You can live in the worst neighborhood with the highest crime in Washington, D.C. The district has said that doesn't mean you get a concealed carry license. You have to be able to document an existing active threat against your life, and then maybe 30 days later, you're told that you can get a concealed carry license.
Well, only if you're expected to have repeated threats. Just one in the past won't get you there. And it's got to be very unique. So if you're in a neighborhood where you're constantly being threatened and everybody else is, you don't get a permit. It's only if you have a unique circumstance. And what that really translates to mostly is that if you're an influential person, maybe really wealthy, campaign contributor, that type of person.
Yeah, but the average person living in Washington, D.C., who might live in a rough neighborhood, who maybe have been the victim of a burglary, may feel unsafe, even walking from their car to their house or walking home from work, they're out of luck.
They're out of luck, and there's plenty of courts that have upheld laws of that type, depending on where it is in the country. The kind of states that have laws like that, their courts will uphold them. So we're talking New Jersey, New York, places like that. And so D.C. is hoping that in the new challenge to its discretionary issuance permitting system, that it'll get a judge that will uphold it. It's always a roll of the dice. They might get a judge who would invalidate it. And in fact, in the existing case, Palmer, which the appeal has been dismissed, there was a motion by the plaintiffs to hold the district in contempt. But at the same time, there was a new lawsuit filed, and that's the one that really is going to determine whether the validity or invalidity of the new law.
As you say, Steve, there have been courts that have upheld these discretionary issue laws. Generally speaking, those opinions upholding these laws have been pretty brief. They tend to point to a line in the Heller decision about longstanding laws not being presumptively challenged, and basically punting, saying the Supreme Court hasn't taken up this issue, so we're going to rule this as presumptively valid. Whereas the Seventh Circuit decision that you mentioned, the original Peruta decision, which is now again before an en banc panel in the Ninth Circuit, these were pretty meaty opinions about why these, and in fact, the original Peruta decision went into some discussion about why these other circuit courts were actually wrong, why the Supreme Court had given guidance to these circuit courts.
Peruta is the original decision by a three-judge panel is the best and longest and most intellectual of all the decisions upholding the right to bear arms outside the home. It's unequaled, and now the full court en banc will rehear that, so all the briefs are being refiled and distributed to a lot of new judges, so it'll go before that court. That decision now is no longer valid, and interestingly, that was one of the main decisions that the district judge relied on in the Palmer versus D.C. case, in validating the D.C. ban. But we'll see where this goes. I mean, the position. Speaking of Heller, let me mention that. Toward the end of the Heller decision, it says, well, there's been few laws in our nation's history that are even remotely equal to the radical character of this total ban on handguns. And it cited three cases where courts had invalidated bans on carrying handguns, not keeping handguns. So Heller actually has already recognized that there, in our history, now and then there have been outlier jurisdictions that have passed laws that are so extreme that they'll be invalidated on their face, and that's exactly what happened in those three decisions from the 19th century. And Heller, the Supreme Court in Heller used that as an example of how extreme these kinds of laws are and why they're categorically invalid.
So are these judges, let's say in the Second Circuit Court, for instance, those judges that are not acknowledging this, Steve, are they just simply not reading this case or as closely as they should? Are they?
They just ignore language like that from Heller. They cherry pick, they pick and choose language that finds agreement. Like in Heller, for example, it states that there are long-standing regulations that aren't questioned by this decision, which tells you nothing other than this decision doesn't make those an issue. But in terms of the Second Circuit upholding New York's law, the Third Circuit upholding New Jersey's discretionary issuance law, they basically trot around the issue and they apply the so-called intermediate scrutiny balancing test issue, the same test that the Supreme Court in Heller condemned. That was Judge Breyer's balancing test for balancing away Second Amendment rights. And so that's not going to be straightened out until the Supreme Court does take the case on the right to bear arms under the Second Amendment. Who knows what's going to happen in California and the Ninth Circuit with the Peruta case, because it's all going to come down to which judges are on that panel and where the majority goes.
Do you think, Steve, I mean, ultimately, as you say, the Supreme Court is the ultimate destination for all of these cases. Even with Peruta going back for another review, is that case still likely the next case to get before the Supreme Court, or they have the opportunity to get before the Supreme Court?
Well, I'm sure whoever loses is going to knock at the door. Whether it will be open or not, that's always the big question. This has been going on for several years now. It started with that Massindero case out of the Fourth Circuit, the case out of Maryland that I handled. There's been one after another where the court has denied cert. And there again, I mean, it's all in flux in the circuit still, as Peruta demonstrates. So the Supreme Court is just waiting to see where it all comes together, and maybe waiting for a mature body of case law to come from more circuits than not, and to see what to do then. And there's that consideration, and there's also the consideration that individual justices might not know where their brothers and sisters stand and how they might vote. And do you want to take a chance? I mean, it's a big determination. I mean, it tells you a lot about what will happen in the future, just as Heller did.
Absolutely. Steve, listen, I appreciate you coming on the program, sir. Thank you so much for your time, and look forward to talking again very soon.
Hope to see you in Nashville.
Yes, sir. We will see you there.